Hello, my name is Agustina Doric and I'm in charge of the competition law portfolio of the Academy of European Law ERA. This is the 30 years, 30 cases podcast series that are aimed at marking the 30th anniversary of ERA by presenting 30 landmark cases of the Court of Justice of the European Union since the creation of ERA in 1992. The judgment that we will present to you in the current podcast is from September 2001 and was delivered by the Court of Justice in case C-45399, Courage at Crehan. In this judgment, the Court of Justice proclaimed the right for any individual to claim compensation from damages caused by breaches of EU competition law based on Article 101 TFEU. This right has been reaffirmed and clarified in later CJEU judgments and was enshrined in Article 3 of the Damages Directive. We will learn more about this case and about the subsequent developments in the field of private enforcement of EU competition law by Michael Jürgen Werner, partner at Norton Rose Fulbright, Brussels, and member of ERA's Board of Trustees.
Yeah, many thanks for inviting me to talk about this really important judgment. And I'm very happy to start by a brief introduction to the background and the facts of the case. Courage and Crehan is definitely one of the shortest cases you can read, but it is a stellar case with regard, a stellar judgment with regard to clarity and preciseness. And it marks the beginning of private enforcement in competition law, which is really a kind of important area starting for the whole competition law sector. It has been brought forward through a preliminary ruling at that time by the Court of Appeal of England and Wales in 1999 and concerned the interpretation of article at that time 85, respectively 81, which later became an article 101 of the TFEU. The case involves is beer. It was with regard to a brewery with the wonderful name Courage that hold a share of around 19% of the UK market in the sales of beer. Courage hold stakes also in a company that leased pubs in the UK, and these pubs were required to buy their beer exclusively from Courage. So it was a conclusively connection between the pubs and the pub owners and Courage. And these prices they had to be paid for often being less favorable in comparison to completely independent pub prices with regards to the sales of beer. The plaintiff was a courageous man, Mr. Crehan, who has been a lessee of two such pubs and a contractual counterparty to Courage, and he had already a history with them for 20 years. And in 1993, Courage brought an action for recovery from Mr. Crehan for unpaid deliveries of beers. In return, Mr. Crehan countersued Courage for damages and claimed that the beer tie was infringing the now Article 101 TFEU. So a relatively straightforward classical case and with a strong notion, of course, of competition law. What was the twist? It was that at the time of the case, national law in the UK prevented a contracting party from claiming damages with regard to an illegal agreement from the other party. Under this precedent conditions, the case would have been already over for Mr. Crehan. But, and to his advantage, the Court of Appeal did not stop on the national level, but asked indeed the ECJ 4 questions on the interpretation of Article 101 TFEU, which then ended up in a kind of revolutionary provision in the next couple of years. The essence of those questions has been in if Article 101 TFU itself could be used as a basis for damages claim, and if such a claim on the basis of Article 101 would enjoy primacy over national provisions that might be contradicted. So quite a specific question with a kind of very broad effect on the national law. That brings me to the fundamental statements of the judgment in this case, and also its precision and why are they so important. The ECJ rendered its judgment in September 2001 in an impressive brevity and clarity. First, the ECJ reiterates on the basis of case law in Van Gent, Los, Costa, and Frankovic that the treaty has created its own legal order. Specifically, this legal order gives rights to individuals, not only where this is expressly foreseen in the contract or in the treaty, better said, but also by virtue of obligation with the treaty imposes in a clearly defined manner. So Courage and Crehan are really in a line from Van Gent and Los and Costa and Frankovic. Based on that, and that's the second point, the ECJ stresses explicitly that Article 101 is a fundamental provision for the functioning of the internal market. One can mark this as one from a constitutional moment in the development of the EU legal order. Third, the ECJ reiterates furthermore, and again on the basis of the case law, specifically in BRT and SABAM, that Article 101 and Article 102 as well, the most important substantive modes in EU competition law, produce direct effects, specifically in relations between individuals, and create legal rights for the individuals concerned with. And that is often overlooked in detail, and national court must safeguard it. So what seems to be a really straightforward message now and a clear position today had been reiterated at that time very clearly by the court. What can be seen as a prelude to answer the questions presented now leads to the conclusion that seems so uncontroversial in today's perspective. Any individual can rely on Article 101 to claim damages before a national court, even he or she is, such in the present case, party to a contract that is liable to infringe Article 101. However, and that should be underlined here, in the opinion of the ECJ, it is not only sufficient to just have the right to claim damages, it must be safeguarded by the now well-known and intertwined concept of full effectiveness of Article 101 TFU, so the FEUT, as well as the practical effect laid down in Article 101. And as a side benefit, such private enforcement through damage claims was also seen by the ECJ to strengthen the deterrent effect and competition law itself that relied for decades mostly on public enforcement through competition authorities. So it's a turning point with regard to the use of the private enforcement in connection with competition. Lastly, the ECJ held that in absence of community rules governing private enforcement at the time, such damage claims have to be governed by national legal systems of each individual member state, and specifically guided by the principles of equivalence and effectiveness. We cannot understate the historical importance of this judgment. Courage was the first time that the ECJ explicitly recognized our right to claim damages for breaches of competition law on the basis of 101. In fact, most member states in the pre-Courage times did not even recognize a right to claim damages for breaches of competition law or rendered them excessively difficult. Therefore, private enforcement of competition law has been almost non-existent for decades, while the public enforcement of competition law made huge progress in the decades pre-Courage, both on EU and member states level. That was in imminent contrast at the time, comparing the EU competition law regime to other juggernaut rights across the pond. In the US, private enforcement of competition law plays an important role right from the beginning of the adoption of the 1890 Sherman Act. Many important judgments and developments in the US can be attributed to private enforcement. As we will see next, the Courage judgment led to remarkable developments for private enforcement in the next 20 years and is continuing to do so. So what explicitly have been the developments after this judgment in the field of private enforcement of EU competition law? The enforcement under the original regulation 1763 has been a rather strict centralized model for decades. The European Commission enjoyed exclusive rights when enforcing competition law in the EU. The Commission was the dominant player in competition law in this respect. Already before the Courage judgment, there has been an intense discussion to modernize competition law enforcement around the turn of the last century. There was consensus that the Commission might not be as effective as an institution when being in charge of too many responsibilities under Regulation 1736. Those developments, to which Courage contributed, led to the adoption of the well-known Regulation 1/2003, that it's still enforced today. One of the main projects with Regulation 1/2003 was to decentralize competition law enforcement in the EU. National competition authorities and national courts were given more responsibilities to enforce competition law, that the Commission could focus on more meaningful enforcement on the EU level than ever before. It was simply opening up the needs for bringing competition law more in the playing field of day-to-day. Regulation 1/2003 and Courage also required national legislators, to adopt their national competition law to be in line. As a consequence, some member states, for instance, such as Germany, introduced a special framework for competition damage claims. Previously, some of the actually existing claimants had to rely on general tort provisions under national law. In parallel, in the mid-2000s, the EU legislature acknowledged that a special EU framework for private enforcement might be necessary to provide some of harmonized framework across the member states, as there have been huge differences between those. As a first result, the Commission published in 2005 a green paper where it laid out different options to create an EU legal framework for competition law damages. The green paper and the preference for specific options within the green paper have been heavily influenced by the US model for private enforcement, because that was the role model in the existing times. One example is that the Commission considered allowing punitive damages, which largely had been unknown in the European legal systems, but not explicitly outruled after the Green Paper has been published in one of the seminal private enforcement cases from 2006, the so-called Manfredi case. The Green Paper has obviously been heavily criticized by different stakeholders within the EU. The main fear was a kind of Americanization of private enforcement in the EU with all the negative impact. The US model of private enforcement had been perceived as some form of control litigation industry that did not contribute to the overarching aims of competition law. As a result, the Commission softened its proposal in the definitive 2008 white paper that was more in line with civil law traditions of most member states. In the meantime, until the final result, the ECJ proved to provide valuable guidance through case law in preliminary proceedings as competition damage claims started to gain traction in the 2000s. I mentioned already the Manfredi case, but it also includes Flyder in 2011, Dona Chemie in 2013, specifically on the disclosure of competition authority, or last but not least, the Kone case in 2014, allowing for umbrella damages. Also in 2014, the legislative process in the EU ended as the Damages Directive 2014-104 has been adopted to provide a first comprehensive framework for competition damage claims. It acknowledged that competition damage claims serve foremost as a compensatory function, while underlining also the deterrent effect in conjunction with public enforcement through the competition authorities within the EU. It includes rules on disclosure of evidence, penalties, the binding effect of national decisions by competition authorities, limitation periods, joint and several liability, the passing on defense, standing of indirect purchases, or the quantification of harm. Subsequently, the Commission published guidelines such for the quantification of harm to help facilitate claims for damages. While it took some more time than envisaged for member states, the Damages Directive is now fully implemented in all member states. It is one of the reasons why we now see an exponential increase of competition damage claims in the last decade. Also, the specific contribution of the Damages Directive is hard to quantify yet. Countries such as Spain, the Netherlands, or Germany proved to become the main fora for such claims in the EU after Brexit. The recast Brussels as well as the Rome II regulation allow claimants for a rather liberal approach to forum shop for the best jurisdiction they deem fit for their purposes. What is important to keep in mind, competition damage claims in the EU are mostly filed as so-called follow-on claims. That means that a competition authority already established that an infringement of the competition law has taken place. Therefore, claimants do not have to prove the infringement itself, which always was a very difficult aspect for them to do. So irrespective whether the Commission or a national competition authority prove the infringement as such, they can base on their decisions the claims for damages. So nevertheless, the connection of public and private enforcement is not without conflict, of course. Many stakeholders hold a sharp rise in competition damage claims, responsible for the sharp decline in the last couple of years of leniency applications of court orders. As you might know, most of the investigations conducted by competition authorities rely on leniency applications. The fear that many cartelists may have is that potential claims for damages may amount to a higher sum than the potential fine by the competition authorities itself, and that filing for leniency may therefore be unattractive. One of the main proposals that is discussed right now in the competition law community is if leniency applicants should be exempted also from competition damage claims to allow them more freely to start a leniency process. Other developments remain to be seen. The damages directive did leave some questions open that have not been picked up by the different instruments as well, such as the question to introduce and harmonize collective action. In addition, the newly adopted Digital Market Act would be another closely related instrument that can further develop private enforcement of competition law or competition laws inspired instruments. Coming back to the time when it all started, Courage and Crehan, a small case, a clear and very, very illustrative decision by the Court of Justice, has started a journey which is not even finished today. It has huge implications on the EU economy and brought competition law in a completely new light, also with regards to those who are victims of competition law breaches. We should congratulate the court for its clarity, its clear wording, and also for the effect it has on the development of the European or the EU competition law. Many thanks.